Hello and welcome. This is 9 a.m. to the point editorial discussion by Niva Yes. In this video, we are going to discuss all the exam relevant articles from the Hindu editorial page. We have two such articles today. The first article is on the banning and freedom of expression. So recently there was a ban on a movie by the Karnataka government. In that context, we'll discuss the idea of freedom of expression, which is important for you from the perspective of GS2 paper of the mains. The second article is on the recent Supreme Court judgments on the issue of arrest. So it deals with a few judgments from 2021 onwards, which will give you enough value addition for the GS2 paper. So let's go to the articles. The first article is on banning and freedom of expression. As I said, it is relevant for you. From the mains perspective, there has been a question in 2024 clearly on these lines. It deals with the idea of freedom of expression and it takes the case of films to discuss that argument. So we'll discuss a typical case study on that line here. The case is Karnataka government banned the film Hamare Bara for 2 weeks. And the reason for banning was in the name of upholding order and preventing communal tension. So the film is said to be a sectarian or a propaganda in nature, and the government felt that it is likely to create communal tensions and there will be law and order crisis, so they decided to ban the movie. So this movie was banned or stayed. Its release was stayed by the Bombay High Court before this, and it later withdrew it because some controversial dialogues were removed from it. So that is the case. Now, what are the issues with banning? Irrespective of the merit of the film, is it justified to ban a film? That's the important question here. The answer is a no, because Article 19 gives freedom of expression as a fundamental right in the Constitution. So this particular film or any other film that has gone through the censor board certification cannot be banned because it has already passed the scrutiny. There it got the certification. Then banning it from the part of the government or the court will violate Article 19. That's the point. Now, this can act as a slippery slope as well because one individual can go to the court, they can get a stay on the release, then such individuals or such groups can hold the producers who have invested the money for ransom. So any form of financial loss will put the producer on the back foot and they'll be ready to give ransom against such litigations. So this can act as a slippery slope as well. Let's see what the Supreme Court has said about this. In 1989, there was a similar case. The case was called S. Rangarajan versus P. Jagjeevan Ram case. And this case was in the context of a movie called Ore Oru Gramathile. In this judgment, the Supreme Court made a statement which says that freedom of expression cannot be suppressed on account of threat of demonstration and processions or threat of violence. The exact same situation that is here. So on the account of threat of demonstration and processions or on account of violence, a freedom of expression cannot be suppressed. And this judgment was not taken out of context. It was taken from the context of a similar case of banning a film. Then what is the way forward for us? So we should be a democratically sensitive and tolerant society that should be open to all the ideas. And the counter to this, the counter to sectarian propaganda should come in the form of facts without resort to unconstitutional method. So banning a film is an unconstitutional method. We shouldn't resort to that. Instead, it should be countered with facts. So this is the takeaway from the article, the relevant case law, the particular case study, and the position, the issues with related to banning and a sensible way forward. So that's the takeaway from it. Let's move to the second article. The second article deals with Supreme Court judgments. This is also in the context of GS2 paper, polity. Let's go into the cases one by one. We have three cases for discussion today. Three of them are on the topic of arrest. The first case is the Siddharth versus State of Uttar Pradesh and another case of 2021. In this case, Supreme Court said that it is unnecessary for the investigating officer to present the accused in custody at the timing of filing a charge sheet. So charge sheet is filed. So FIR is the first procedure. It is the first information report. Then after the investigation has taken place, the investigating officer will file a charge sheet. So at that time, usually the accused is detained in custody. When the charge sheet is produced in the court, the accused is detained in custody. And this process of detaining can itself be a punishment, because you know the social taboos are associated with arresting in India, and the person who is inside will be restricted to act for himself outside. So this Supreme Court judgment can be seen as a landmark move in that direction, because it says that the investigating officer need not arrest the person while filing the charge sheet. It further reiterated that Section 170 of the CRPC does not impose an obligation on the officer in charge of a police station to arrest each and every accused at the time of filing charge sheet. So this is complementary to this, because section 170 deals with the arrest and filing of charge sheet, and the court clearly says that it does not impose an obligation on the officer in charge. So the officer in charge can do the investigation and make the arrest, make the filing of the charge sheet without arresting the accused. That's the judgment. The second judgment is on Pankaj Bansal versus Union of India case, a very recent judgment in 2023. In this judgment, the court said that the ground of arrest, the reason for arrest, must be informed in writing to give true meaning and purpose to the constitutional and statutory mandate of Section 19(1) of the Prevention of Money Laundering Act. So this judgment was given in the context of the PMLA Act, and it clearly says that the ground of arrest must be informed in writing. This was not a passive judgment, because in the recent Prabir Purkayastha case of 2024, the Supreme Court reiterated the Pankaj Bansal judgment and extended its ambit to UAPA cases also. So you know, under the PMLA Act or the UAPA Act, arrest happens very soon, and the burden of proof often falls on the accused rather than the investigating agency, and the process itself becomes a punishment in such cases. The Supreme Court comes to the rescue there, and it clearly informs that the ground of arrest should be given in writing to the accused. And what are the advantages of these three judgments? First of all, an accused person can seek legal counsel and seek bail on the basis of unambiguously stated facts. So if it is given in writing, the reason or the ground for arrest should be mentioned in that, and the investigating agency cannot move from that position at a later point. That means the accused can fight the legal battle on the basis of what is given in writing. That is the major advantage. Second, it is in the spirit of Article 22, which deals with the constitutional protection against arbitrary arrest and detention. So these three judgments supplements that. So in the previous slide, we have seen a question on the freedom of expression, which is Article 19. If there is a question on Article 22, which is arbitrary arrest and detention, these three court cases can be quoted. And third, as I just mentioned, the process itself is a punishment in such cases. So if arresting is not taking place before filing the charge sheet, the process won't become the punishment. All these provided that the accused is cooperating with the investigation and the investigating agency. If cooperation is not there, arrest will become mandatory. So these three cases are quality value additions for an answer in the GS2 paper of the mains. That's the takeaway from the Hindu editorial page of June 12th. Thank you for listening.